Good morning, honorable members, and good morning to all our guests on the platform, including all the witnesses who will be giving testimony today. Let's start with our meeting. Anele, are there apologies?
Good morning, Chair. On my side, I did not receive apologies from members. Thank you, Chairperson.
Okay, there are no apologies from members. We hope that all members are on the platform. As I welcome the members to the portfolio committee, maybe just to comment a little bit about the debate we had yesterday on the budget vote of the Department of Higher Education and Training. I think we had a very good debate. Almost all the parties who are consistent in attending this portfolio committee had an opportunity to participate and were able to listen to their arguments about the budget vote. Of course, when we are in the House or in mini plenaries, it's quite different from when we are here. Parties get their mandate, they come and articulate their views in mini plenary. And of course, there is also a little bit of, using the gallery. But in the overall, I think it can only strengthen the kind of democracy that we have in this country. To have different views expressed about the performance of government, about the budget that is allocated. So it serves to strengthen democracy, to have the multiplicity of views. And those views must be encouraged to be expressed in an open forum like we had yesterday. So it was a good one. And I would like to thank members who participated yesterday. There is another debate next week on Tuesday of the Department of Science and Innovation. So we will also expect that members will participate in that debate, express their views as robustly as they are mandated by their parties. Because at the end of the day, it becomes a festival of ideas. It becomes an expression and contestation of views, which, as I said, is very, very good for democracy. Okay, let's get into today's meeting. Now, we have changed the program slightly and would like to apologize to the VC of Univen. When we closed on Wednesday, we requested that he must come so that he's the first to give testimony. But there were some developments on Thursday during the testimony of the chairperson of council. It became clear that we needed to invite the registrar, the current registrar, Dr. Jeffrey Mabelebele, to come and clarify some aspects that related to some submission of documents to the Senate and the Institutional Forum. So the registrar requested that he would like to be the first because there is a meeting that he had arranged and he's not able to move that meeting. So we agreed with that because it was sort of short notice on our part. So we felt that I think it's a fair request. Let's accommodate him and start with him, and then we'll get to Dr. Ntambeleni, the Vice-Chancellor of Univen. If that is fine, we can then proceed and request that, can I check if the registrar of SMU is on the platform?
Good morning, Chairperson. Good morning, members of the Portfolio Committee and other guests. I can confirm that I am on the platform, Chairperson.
Okay, thank you very much. I'm going to invite legal services, as always, to assist us with the administration of the oath. And when they do that, Dr. Mabelebele, you will have to switch on your mic and your video so that we can see you. Okay, thank you very much. Over to you, Mrs. Kangen.
Good morning, Chair, and to all on the platform this morning. Dr. Jeffrey Mabelebele, I'm not sure if I pronounced your name correctly. You are required to take an oath in accordance with Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004 to appear before this committee as a witness and to answer questions related to the oversight inquiry into the appointment of Professor P. Mbati as Vice-Chancellor of the Sefako Makgatho University and other related matters. This is Part B of the inquiry. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or the documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a committee with information or makes a statement before it which is false or misleading commits an offence and is liable to fine or imprisonment for a period not exceeding 2 years. You are required to take an oath or an affirmation that the evidence that you're about to give is truthful. You may choose to take the oath or the affirmation. Which do you prefer?
Well, I would choose to take the oath, Chair.
Please raise your right hand and state after me. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth, so help me God.
shall be truth and be held truth and nothing but the truth, and so help me God.
Thank you. The witness is sworn in, Chairperson. Thank you.
Okay, thank you very much, Mrs. Kangen. As always, we appreciate your assistance and your services. Registrar, you are welcome to this inquiry. We appreciate you making yourself available at such short notice. And as you can see, we've tried to accommodate your request that we must be the first to give testimony. We appreciate that you were able to come. Maybe we should allow you to take us through your prepared statement, after which we will then ask you some questions. Over to you.
Chairperson, thank you very much. And let me also start off by thanking you for allowing me to be the first witness to come onto your platform. I do not take your acceptance of my request lightly. Well, as you can imagine, Chairperson, I received a letter from yourselves
Dr. Mabelebele, your video is off.
Oh, must I switch it on? Thanks. Sorry about that. Sorry, Chair.
Okay.
I was saying that I would first like to start off by thanking you for the opportunity you presented to me, and also for accepting my request to appear before you as your first witness for today. My statement relates to the two matters that you have raised in your letter that was given to me, sent to me on the 12th of May 2021, in which you indicated that the chairperson of SMU Council, Ms. Rambaula, appeared before the committee on the 12th of May 2021, wherein she gave oral evidence to the statement submitted to the committee on the 29th of June 2020. During her testimony, Ms. Rambaule could not provide responses to the committee on a number of issues and indicated that the registrar would be in a much better position to give clarity to the committee. And in your letter, you proceeded to say that in light of the above, the committee requests you to appear before its inquiry to give response to the following allegations. One, that the Senate and the National Forum were not provided with Prof. Mbati's sexual harassment disclosure records, and they were voted on the shortlisted candidate with no knowledge of the disclosure. Bullet number 2, that the chairperson of council was not aware if Senate and if IF were not provided with disclosure records, which were in the agenda packs distributed to the council. My statement, Chair, is going to be confined to those two matters that were raised in your letter. And I can perhaps start off by indicating that in terms of the first matter that you have raised in your letter, the Senate and National Forum were not provided with Professor Mbati's sexual harassment disclosure records. And they indeed voted on the shortlisted candidates with no knowledge of the disclosure records. I can confirm, the Chair, that on the agenda pack of the Senate and National Forum, respectively, were the following documents: the advert for the position, the policy on the appointment of the Vice-Chancellor, the application letters and the CVs of the 4 candidates that had applied for the position of the Vice-Chancellor, being Prof. Mbati, Prof. Moche, Prof. Parek, and Prof. Sonia, and also their application letters. I think I've already touched on that. Chairperson, this particular arrangement was done in accordance with paragraph 2.2.3.2 of the policy that I referred to, which provides that the 2 structures should be provided with a full CV of each candidate and their declaration of interest. And therefore, for that reason, Chair, there were not any other documents except those 2 that I referred to. As I indicated, Chairperson, as I understand it, Chairperson, the disclosure of the records happened at the selection panel of the council, which took place on the 16th of April 2020. In terms of the chronology of events, the Senate meeting took place on the 11th of March 2020. The National Forum took place on the 11th of March 2020. The selection panel took place on the 16th of April 2020. And the council then took place, the council meeting took place on the 24th of April 2020, where Professor Mbati's appointment was made. On the second matter that you have raised, Chair, I think you indicated in your letter that the chairperson of council was not aware if Senate and National Forum were not provided with the disclosure of records, which were in the agenda packs distributed to the council and selection panel. I cannot confirm or deny that the chairperson of council was not aware if Senate or IF were not provided with the disclosure records. The reality of the matter, as I've indicated in my view earlier, was that these disclosure records became known to the council selection panel when the council selection panel met on the 16th of April 2020. Therefore, in my submission, Chair, it would not have been possible for these particular records to be part of the Senate and IF meetings of 11 March 2020. I therefore render an opinion, Chair, that it is quite possible that the Chair was not aware for the following reasons. One, she's not a member of either Senate or IF. And then, as I've indicated earlier on, these particular full records became available, at least in a meeting of the 16th of April 2020. I think that would be my short statement on the matter. And I would then allow you and the members of the committee to ask questions as I confined my statement to those two matters that you've raised. Thank you very much.
Thank you very much, Dr. Mabelebele. Am I pronouncing it correctly?
Absolutely correct, Chair.
Okay. You say in terms of the policy, the documents which are supposed to be supplied to the Senate and the IF is the CV, the disclosure forms, and what else? Can you just confirm what are the documents?
Chair, I said there are two documents that are required to be provided to the selection committee in terms of section 2.2.3.2 of the policy. If I may read it out just for the benefit of yourselves and the committee. The Senate and the Institutional Forum must, after all shortlisted candidates have addressed the joint meeting of the Council, the Senate and Institutional Forum on a topic or topics as determined by the selection panel with due regard to the advertised requirements for appointment, through separate meetings, make a pronouncement on the suitability for appointment of each of the shortlisted candidates, the full curriculum vitae of the candidates, and their declaration of intent must be made available to the members of respective meetings before voting is conducted.
So it's declaration of intent.
Yes.
What is that document?
Well, my understanding is that it could also include the letter of the application, what they intend to do if they were to be successful candidates and ultimately appointed to serve in the position of the Vice-Chancellor.
So it does not require the disclosure in terms of all the things that the Council and the Senate would know about this candidate.
Well, as I said, Chairperson, I confine myself to the policy. It does not pertinently and definitively ask of the two committees to be furnished with the sort of document that you referred to.
Okay. So in terms of the selection panel, what does the policy say has to be supplied?
Quickly, candidates. And then recommend in its exclusive opinion, the successful candidate to the Council of the University for approval. Now, in terms of the specific documents that are required by the selection panel must consider the full section 2.2.4.5 of the policy. It says, Chair, the selection panel must consider the full curriculum vitae, declaration of intent, the referee reports in respect of each candidate on the shortlist, as well as the results of the voting by the Senate and National Forum on the suitability for appointment of the shortlisted candidates, and the report of the qualified service provider, if applicable, referred to in clause 2.2.5. And this qualified service provider, I submit, Chair, should be the agency that has been appointed.
So it's not specified that the disclosure must be the full disclosure of the candidates must be made available to the selection panel. It's not something that is it's assumed, it's not necessarily specified in the policy.
Absolutely perfect, Chair. It is not something that is pertinently expressed in the policy in definitive terms.
Yes. So, would you say that information that should be available to the selection panel should be also available to the Senate and to the institutional forum? Because it's information that is required for them to decide on the suitability of the candidate. Would you say that it should almost be the same set of documentation?
Chair, it's going to be very difficult for me to hazard a view on this matter. As you can imagine, I'm not a council member, and I'm just a registrar whose role really is to ensure that there is at least some compliance on matters that council is dealing with. My own view is that, well, we have, as a university, I think we have learned out of this experience. First, I would say, it might be appropriate, depending on how you look at it, Chair. It might be appropriate to look at it to ensure that those documents are made available to the relevant structures. But one thing that we must also take into account is that the process to appoint the Vice-Chancellor has got checks and balances from the date of the advert right up to the appointment by the council. So all of those committees and their quality assurance mechanisms in place. If the selection, the Senate and the Institutional Forum have not been provided with those kind of documents that you referred to, that particular defect, if it is a defect, could be picked up down the line when the process unfolds. The other view that I think we must also take into account is whether our policy in its current arrangement we should switch the sequence in that the two structures that you refer to, Senate Institutional Forum, do not just vote on the suitability of the candidates after shortlisting, but they vote on the appointability of candidates before that particular candidate is forwarded to council for approval. That candidate or candidates are forwarded to council for approval. The point I'm making, Chair, is that, and I'm hazarding a view here, it is not something that is within the domain of my work, but I'm just saying it might, going forward, it might be appropriate for us to look at those kind of amendments to ensure that when the two structures sit, Senate and Institutional Forum, they are able to vote on the appointability, the recommended candidates from the selection panel, so that they can be afforded a view in terms of their separate mandates. That would be my own opinion on this matter.
Okay. Yeah, you say that the policy is such that if there is a defect, that defect will be corrected at some point in the process. So there was a non-disclosure, as we know, and this non-disclosure was not corrected in a sense that the Senate was not given an opportunity to apply its mind again, given the information that was made available to the selection panel. So Senate was never reconvened. The Institutional Forum was never reconvened to say to them, look, there is more information that has come. Can you apply your mind to this information and vote again and give us your consideration of the suitability of the candidates? That was never done.
Chair, yes, I would agree that it was never done, but we must proceed, Chair, from the premise that the two structures would vote on whether the shortlisted candidate is suitable for appointment or not whether that candidate can be appointed. the process to appoint that candidate has to go through, first the candidate has to go through the interviews by the selection panel. And at that particular, or at those interviews, the information I have is that that information was then disclosed. And if the selection panel was not convinced that the process could go further, it had all the right to stop the process from there.
Okay,
My sense is that in its exclusive opinion, the selection panel decided that the disclosure was adequate. In any event, the disclosure the disclosure that was made was not that adverse, in the sense that the court, as I understand it, had already cleared the candidate of the allegations that were leveled against you.
Okay, let's not get into that.
Okay, sorry.
If you want us to get into that, we can get into that.
No, I wouldn't want to, Chair. My apology, I wouldn't want to.
We can probe your knowledge of the level of disclosure and the adequacy of the disclosure, because you are offering an opinion. But maybe we'll have to get to that. But let's confine ourselves to the Senate and to the institutional forum. You say that the selection panel, if it's convinced that the disclosure was adequate, but what we know and what was confirmed by the chairperson is that the chairperson was not aware that the Senate and the institutional forum did not get that disclosure about the history of that allegation of sexual harassment. So the chairperson would not have known that the votes that they are getting from the Senate, it's an outcome that was informed by the same set of documentation that she was having. Okay. That one she did not know. Okay. Now, what do you think is the relevance for the Senate and the institutional forum to vote on the suitability? Is it something that is insignificant? Something that is just a ticking of the box, or it's a fundamental part of the selection process?
Well, I would say it's a fundamental part of the selection process, Chair.
Okay.
The Senate. Oh, sorry.
Let's just, if it is a fundamental part of the selection process, surely it has to, the Senate and the institutional forum, these two structures, should receive the adequate and comprehensive disclosure about the candidates that they are voting for. Would you agree with that?
Well, I would say, Chairperson, that they should receive information that would enable them to exercise their mandates, separate mandates, as it were.
Yes, so they have to get adequate and full disclosure about the candidate they are voting for. That's what I'm asking. Would you agree with that?
Well, Chairperson, I would say that the information that they should get, the minimum information that they should get, is the one that I've articulated in respect of the policy that I shared with you. If they felt that they...
Question. I'm asking if, in your view, do you think it is fair for the institutional forum and for the Senate to receive all the necessary information about the candidates that they are about to vote for? That's my question.
I would say yes, they should.
Okay. In this instance, there was a material information that was not brought to their attention, which is the full disclosure on the allegation of sexual harassment. They did not get that information. Now, we had the then chairperson of the Senate on Wednesday. We asked him a question: do you think this information is material? He said to us, absolutely. It's absolutely material, because as the Senate vote, they vote on the academic suitability. They look at the academic, whether the person has got enough academic experience, published papers, has done this, lectured, and all of that. So they say they don't only look at that, they also look at the character of an individual they are supposed to vote for. And that information is material towards them determining the character of all the candidates they were going to vote for. Do you agree with that?
Well, Chair, you are putting me in a very precarious position. You are putting me in a very precarious position, Chairperson.
No, I know. I
Because
just want you to admit the obvious, because this is just an obvious thing.
No, it's not as obvious as you are putting it. Remember, Chair, I'm putting it before you that the two structures in terms of our policy are required to receive a set of documents, a minimum set of documents, as I've explained before. And I would, if I were to venture a view, my own view is that would be different, slightly different from what the chairperson or former chairperson of Senate articulated. I would say, in fact, it would be more radical than that. I would say, if we were to, going forward, if we were to change this particular policy, it might be appropriate for us to consider convening the meetings of the two structures after the meeting of the selection panel, so that whatever comes out of the selection panel, set of documents and so on and so forth, and other tests and references that would have been considered by the selection panel will then be put before these structures, these two structures. That will be my view.
Yeah. In fact, I think you are even taking it too far. As you say, it's even radical. You know, you say that, in fact, your proposition is such that the two structures must come after the selection panel. So in any case, they may even have to evaluate the work of the selection panel. So that's how radical you are putting it.
Not evaluate, Chair. I don't think I'm saying evaluate.
But it has the effect of evaluating. It's not intended to evaluate, but they vote on the candidates after they have gone through the processes. So
yes,
if they vote against what, for instance, the selection panel has done, I mean, it's more like evaluating, not that it may carry anything, but it has got an effect of evaluating the work of the selection panel. But I think we agree that it's absolutely necessary that all the relevant information pertinent to the decision that they are required to make must be made available. I think there we agree. Now, we also, earlier on, I did say that the kind of disclosure that is made by the candidate about their past history and record is not something that is explicit in the policy, but it's an expectation. That's something that we also agree with, isn't it?
No, Chair. I think now you are putting words into my mouth. I'm not agreeing that.
What did we say about that? Because I thought we had agreed that that issue is not necessarily specified in the policy. What we were reading, that there must be background checks and all of that. Is it in the policy? Okay.
what I said, Chair, was that the 2 documents required for each of these committees is their CVs and their declaration of intent.
No, there we are done.
Okay.
Let's go to the selection panel. What are
Okay,
they?
all right.
What does the policy say? Is it specific that you must conduct background search of the history of the
Let me check. I'm with you just now, Chair. Well, I'm just going to say that I'm just going to read out the policy, various sections of policy, then I'll respond to a specific question.
Okay.
First, it says, before the candidates on the shortlist are interviewed, the Executive Director, Human Resources, must take appropriate steps to confirm all the candidates' qualifications. Secondly, it says, a meeting of the selection panel must be convened as soon as possible after the joint meeting of Council, Senate, and Institutional Forum. And the selection panel will at this meeting conduct interviews with all the candidates shortlisted. Then it says the selection panel must consider the full curriculum vitae, declaration of intent, and the referee reports in respect of each candidate on the shortlist, as well as the results of the voting by Senate and Institutional Forum on the suitability for appointment of the shortlisted candidates, and the report of the qualified service provider, if applicable. These are the kind of reports that the selection panel will consider.
Where is the policy saying that there must be background checks which must be presented to the selection panel and the selection panel must consider it?
Well, the last part of the paragraph that I read out says, and the report of the qualified service provider. So that report of the qualified service provider will, depending on the brief that the provider has been given, will contain all manner of facts, including the background checks, disclosures, and other related matters.
If applicable, that policy says if applicable.
Yes.
So
if the service provider has been appointed.
Yeah, that policy does recognize that sometimes it may not be applicable. We agree with that.
Yes, we agree with that. I agree with you that it does accommodate that there could be instances where service provider is not appointed.
Yes, it says if applicable. So
yes.
Sometimes the service provider may not be applicable. So the policy is not expressly stated that there must be background checks and the candidate are supposed to provide all of that info. It's not expressly provided, but we all know that that is the important part of the process. That when you appoint a person, you need to know this person not only from the CV, you need to make sure that this person also discloses any other thing that is relevant for the panel or for the university to take a decision. That's why in the pack there were those disclosure forms in the pack of the selection panel.
Yeah, but also, Chair, what I must also indicate to you is that at the selection panel meeting itself, there is a standard question that the university across all layers pose to candidates who would wish to be appointed to any of the positions that would have advertised. And that particular question probes members or candidates to disclose any information that could jeopardize their candidature for the position. So apart from the policy, there are other checks and balances that are there to ensure that the process is not compromised.
No, of course, yes, you're right. It's a necessary part of the process, registrar. Any institution must understand the history and the background of of the candidate, whether it's expressly stated in the policy or not, but they have to do that. But all what I was saying is that this information is necessary, it's material, it's relevant to the two structures that are voting on the suitability. That's my submission.
Well, Chair, if we were to bring this matter home, the disclosure of the sort you have information on and the committee has information on, even if it was made, would it have had a material impact on the voting outcome of both structures? That question, I think, can only be answered by the structures themselves.
Well, they were here. Let me just give you some information. They were here, both of them. And they did say they did not get that information, but this information was material to their own decision-making process, meaning it could have influenced them either way if it was made available to them. So that's what they say, both of them. What would you say to that?
Well, I think my view would be that it is quite possible that they would have voted differently. In the ultimate end, the Council of the University is the one with the authority to make a call,
yes,
on the appointment of the Vice-Chancellor,
yes,
informed by the recommendations of the selection panel. Let's, for instance, take for granted that they made that particular determination, that one specific candidate was not suitable for to be interviewed. The Council of the University, the selection panel would have debated that, would have arrived at a particular decision. And that decision could have been that we are not proceeding with this candidate, or we are proceeding with this candidate nevertheless. And in the instance where they proceed with the candidate nevertheless and recommend to the council exercising its own authority could have also proceeded with the appointment of the candidate. Yes. I'm just saying that I see the issue of materiality that we are raising, which is important. I'm not trying to undermine it. But I'm just saying that must also be counterbalanced by the authority and the powers of the council in this respect.
Yes, you are right. You are right. Now we are in the realm of speculation. You see, council might have, council might not have. But what is important is whether the information was made available, and is it reasonable to say that it might have influenced the decision of the two structures, which we have already said, no, it's possible. You've already agreed that the process of the Senate and the institutional forum, that voting is not just a mere ticking of the box, it's a fundamental requirement of the process of selecting the Vice-Chancellor. So it's not just a mere rush thing, let's just vote quickly. So that voting, your policy requires that the selection panel must consider the voting of the two structures. So it's quite material, it's quite a serious issue that they have to look at. Looking at it, if they don't apply their mind, given whatever that has come from there, it's also something that may also influence council when they submit their report to council. So the fact that this information was not available to them, it's a serious procedural defect. Would you agree with that?
Well, procedural defect, depending on where you derive that particular summation from, inference from. if I were to stick to the policy, procedurally, the university would have complied, even without providing the two structures with that information.
Yeah,
so
but
I wouldn't totally agree with you, but I would agree with you at level of principle that says the two structures need sufficient information to exercise their mandate.
Okay. All right, let's go to, you offered an opinion on the court and the adverse nature. Do you still want to go there, or must we leave it?
No, let's leave it. I think it's within your, I'm not an expert in that. I was just
No, because it's an issue that we canvassed with the chair, because the chair also offered a similar opinion that the Professor Mbati was cleared. There was there was nothing adverse. So we took her through the information that we have, and she was actually quite shocked about the information that we had to share with her. So I don't know whether you also want to enter that terrain.
No. As a non-council member, chair, I'm not a council member. So okay. my role, I think, is to help you to execute your mandate in terms of the terms of reference of the inquiry. I wouldn't want to go in there.
All right.
I'm leaving that to the committee.
Yeah, but it's incorrect to say that there was nothing adverse. That statement is incorrect, if I can just put it to you. You don't have a comment on that?
No, I don't have a comment, Chair. I think the point that you made, I think, is clear. I don't want to venture into that debate. I think I'm leaving it to you because I might not have the information that you have. It will be very difficult for me to enter into a debate when we are moving from two different things. So I do not have that kind of information. I'll leave that.
All right. No, from my side, I think I'm okay. Unless if I think of something, can I just check with the members if they say Honorable Litzia?
Thanks very much, Chair, and good morning to yourself and all honorable members and all our guests today from the department and from Sefako Makgatho, including
to the selection panel. As to whether and then secondly, I can confirm that at that meeting, at least from the reports that I've read, at that meeting, the Vice-Chancellor did make a disclosure. The candidate who was ultimately appointed to the position of Vice-Chancellor did make a disclosure about his past, and that was recorded as such in that meeting.
Okay. So having read to us, and I want to be careful because yeah, maybe let me leave that one. Maybe let's go to the policy. Having read those sections of the policy now to us, are you therefore not of the view that the policy has some gaps in it that may require a review? The parts that you were reading to us.
Well, Chair, certainly on matters like this, Chair, including legislations, by the way, from time to time, once you put them in an implementation mode, you are able to identify possible and potential blind spots. And once those possible and potential blind spots have been identified, there would be grounds for review. That is why, for instance, all our policies, there's a timeline that within 3 years or whatever, those must be reviewed so that they remain relevant and current to deal with the situations that we find ourselves in. This is equally applicable, as lawmakers would know, to legislation. So I would say at a general level of generality, that yes, policy of the sort we are talking about has to be reviewed to ensure that it remains current, it remains relevant, and it assists the university to deal with potential blind spots that might be inherent in such a policy.
Yes, and I don't want us to be general. We're talking about this particular policy, and I'm asking for your opinion as the registrar of that institution. That would you agree with me, or would you concede that this particular policy has some gaps in it, and that may require a review? This particular policy, and I don't want us to be general. We understand that what you are talking about in general, but I'm speaking about this particular one in general.
Yeah, well, I would say that yes, as I said, even this policy, it is there are grounds for us to review it, I would say.
Oh, okay. No. Well, I think the point which I want to drive home that my belly is that you, according to the policy which we have went through, you individually did nothing wrong, and there's no need, for us to even go into that. We just wanted to understand. You implemented policy as you read it, and that is commendable. That is okay. Here I can't find you at fault. I was just wanted us to deal with this matter of policy without necessarily trying to, sometimes when we ask questions, it's not that we want to find you at fault, and it does not help either ourselves or yourselves to sort of come out as defensive. So because we're not trying to find you guilty, we're not, you're not at trial, just trying to create a situation where in the near future or in future, when such things happen again, at least we are very clear. And another piece of advice is that in future, when somebody asks you a question, don't go into or don't venture into territories where if we were to ask questions about that, you'll not be able to answer. So confine yourselves to the questions, and at least questions that you'll be able to provide evidence on them. And the point in case is the one you almost ventured into. Well, if I was the chair, I would not have asked you if I want to go there, because we would have introduced the issue of being cleared by the courts. We could have went into that, and I don't think it's for you. If that was part of the report by the service provider, they will provide answers for that. Having said that, I think we're on the same page, but you can respond if you want to respond to what I've just said.
Well, Chair, I take your advice to heart. I take your advice to heart, and that of the chairperson. As I said earlier, when you are in my position, you respond on the basis of information that you have. Sometimes that information might be limited, and I take your advice to heart. Well, on the policy specific, remember I even mentioned when I responded to the chairperson's questions that my view would even be a more radical one in terms of the sequencing of the committees. And that would certainly allow us to ensure that the validity, reliability, and the integrity of the outcomes of the appointment process are fully defensible from advertisement right up to the point where appointment is made. I did venture a view. So I think flowing from that, yes, my view is that there are grounds for it to be reviewed.
All right. No, thank you very much. And thanks, Chair.
Okay, thank you very much. I think, Dr. Mabelebele, you have been very cooperative. Witness and you know, sometimes witnesses come and they deny the obvious. You know, something, if it's obvious, it's obvious. If something is material, it's material, you know. But but despite everything else, I think we find we just needed you to confirm those two things. But there is an issue that was raised by the chair of council, information actually, because I asked if there is any independent process they follow to verify the information they get. She said no, they appoint external legal advisors to advise them. I wonder if in this case there was a lawyer or an independent legal person who was appointed to advise and to comment on the information that was received in terms of disclosure of all the candidates. Was there such a legal advisor, law firm, counsel, and whether that opinion was available and it was shared with the selection council, members of the selection committee and members of council?
Well, Chair, because I was not a member of the selection panel, my knowledge, I don't recall that there was a legal expert appointed to validate or verify the accuracy or otherwise of the disclosure records presented to the selection panel. We only appointed a law firm to assess the extent to which the appointment process was procedural. And that particular opinion, I think, was shared with the portfolio committee.
Okay, but that was after.
It was after, yes, it was after, yes.
Okay, so in as far as you are aware, there was no law firm, counsel, or any other legal advisor who was appointed to look at the disclosure and to advise counsel. Well, you don't sit in a selection panel, so would not know about that. But at the level of council where you sit, I think you are the secretary of council. That information was not available.
No, it was not available.
Okay, so we can assume that there was no legal firm that was appointed to look at this disclosure.
That will be a safe assumption, Chair, because if there was, I would have known about it.
Yes, you would have known as the secretary of council and as the person who supply the packs, the information packs for these committees of council. So you should have, you would have known if that was the case. Just confirm.
Yes, no, I would have known, Chair. I thought I confirmed. I would have known if that was the case.
All right.
I would have known.
The records does not say that the registrar has nodded his head in agreement.
Okay.
Okay.
Thank you, Chair. Sorry about that.
Dr. Mabelebele, thank you very much for that. And thank you for coming. You are excused. You can attend to your other activities. Is there anything you want to say?
Just to thank you, Chairperson, and the committee for really allowing me to be the first on the platform. And,
Okay.
I wish you everything of the best. Thank you very much.
All right, thank you very much. You are excused.
Thank you so much.
Okay, can I check with whether the Vice-Chancellor of Univen is on the platform?
Morning, Chair. Yes, I am on the platform.
Okay, thank you very much for coming. We will have to administer the oath again, and we'll have to invite Mrs. Gangen to do that for us.
Thank you, Chairperson. Good morning, Dr. Bernard Ntambele.
Good morning, ma'am.
You are required to take an oath in accordance with Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004 to appear before this committee as a witness and to answer questions related to the Oversight Inquiry into the appointment of Professor P. Mbati as Vice-Chancellor of the Sefako Makgatho University and other related matters. This is Part B of the inquiry. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges, Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take the oath or an affirmation. Which do you prefer?
I'll prefer an oath, ma'am.
Sorry, may I just ask you, did you say an oath or an affirmation?
An oath. Oath.
An oath. Please raise your right hand and state after me. I swear that the evidence I shall give
I swear the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth and nothing but the truth.
the whole truth and nothing but the truth.
So help me God.
So help me God.
Thank you. The witness is sworn in. Thank you, Chairperson.
Thank you very much, Mrs. Gangen. VC, thank you for coming back. And please accept our apology for scheduling you after the registrar. I'm sure you're on the platform. We explained the reasons why we had to take the registrar before yourself. My apologies for that. I just want to confirm that we did receive a correspondence from yourself on the issue of the task team report. When the chair of council was here, we asked questions about the task team report, and we insisted that we need to get that report. But we got a letter from yourself. I just want to go to that letter, which indicated that that report is not available in the records of the university. So it's quite something, because we're not going to have a benefit of what exactly the I'm trying to get that. I'm not able to get your letter, but yeah, we did get a letter from yourself confirming that the task team report that was supposed to be presented to council is not available. And so it's quite a pity that we can't get that type of record. I wonder why. Maybe if we can just briefly talk to that. Was the office of the registrar not not involved? Because normally when the registrar, as I understand, they provide secretarial support to all these committees. Were they not involved with the task team investigation that was appointed by council?
Thank you, Chair. I wouldn't certainly give a clear answer who was involved, safe to say what I stated in my statement, Chair.
What did you say in your statement? Maybe if we can just put it for the records.
Can you allow me to go through my statement? Should I go through my statement?
Which statement? I was referring to the letter, and I wanted just some clarity whether was the registrar not supplying secretarial services and therefore taking minutes of all this, because the task team would constitute a committee of council because it was appointed by council. That's all what I was asking. I don't know which statement. You want to go to your statement or to the letter?
Or to the letter that you received?
Okay, yeah, no, we can make reference to the letter then.
Okay, thank you, Chair. Thank you, Honorable Chair and members of the Portfolio Committee. My statement is dated 13 May 20. My letter is dated 13 May 2021, addressed to the Honorable Mapulane, Chairperson of the Portfolio Committee on Higher Education, Science and Technology. And the subject refers a request to appear as a witness before the Portfolio Committee on Higher Education, Science and Technology, Oversight Inquiry into the appointment of Professor Mbati as the Vice-Chancellor of Sefako Makgatho University and related matters. Paragraph 1, I refer to my appearance before the Portfolio Committee on the 11th of May 2021 and deliberations that took place during the engagements regarding the above subject matter. Para 2, in accordance with this resolution of the Portfolio Committee, I'm required to appear before the Portfolio Committee on Friday, 14 May 2021 for further engagements and questioning. Para 3, I've been requested to submit a report of the tax team that was appointed by EXCO to investigate who authorized the decision to review the CG report and whether there was inappropriate use of university resources in the respect of the then Vice-Chancellor's defense on the matter. The committee also requested me to provide instructions that were given to the university attorneys Bowman, which relates to the Portfolio Committee's concern of the contemplated interdict. Para 4, my response is tabled as follows. 4.1, as per the records in the form of the letter dated 9 March 2015, written by the then Chairperson of Council, Mr. Maja, to the Registrar regarding the resolution taken in the in-committee meeting of Council held on the 20th of February 2015. I confirmed that the tax team was appointed to investigate the process followed in respect of the decision taken for the university to review the CG report and whether there was inappropriate use of university resources in respect of the then Vice-Chancellor's defense on the matter. The tax team was to investigate and make recommendations to Council on appropriate course of action to follow. 4.2, The letter of appointment of a tax team dated 9 March 2015 is attached here too and marked Annexure SP1. The document containing minutes of EXCO meeting dated 10 April 2015 is attached and marked SP2, and it appears the minutes were taken by Mr. Molapo because this was an in-committee meeting comprised of external members of EXCO. 4.3, to my knowledge and having conducted a search through the university archives, there is no record of the report of the tax team. This is a matter which I cannot take any further. 4.4, finally, I've been requested to provide instructions that were given to university attorneys, Bowmans. The instructions to Bowmans is in the university's records. However, I'm advised that any correspondence between the client and its legal representative is legally privileged. Accordingly, I'm not able to share this information with the portfolio committee. Para 5, I trust the above is in order, and I confirm I will attend the inquiry on the 14th of May, 2021. Signed, Dr. Binta Melin.
Okay, thank you very much. Now, my question was, this information is not available in the records. The report of the task team. My question is, in your recollection, was this task team not supported by officials of the university, as is normally the case with all other committees of council?
Yeah, I wouldn't speak to these specific issues because I was not, closely, in those tax team. Whether they, I don't, cannot, certainly give a precise to say whether there was a secretariat, for this and that, but all what I can confirm, because I had to check with the secretariat, they have not said to take minutes. As I referred to the minutes that I shared with you, those minutes were taken by a member of the EXCO. So it appears that, those were, in my view, as I read the records to you, that, the secretariat is in this case now that I'm talking about, is not set to take those minutes in.
Okay. All right. It's fine. Let's leave that one. Dr. Tabeleni.
Yep.
Dr. Tabeleni, you'll recall that when we reschedule your appearance, you were not able to answer certain questions put to you by Honorable Litsie, because you said you needed to consult so that you can refresh your memory. Were you able to do that?
Chair, what I did when I received your letter that sort of require me what I should do here today, it was to the effect that, I must provide you with the documentations, which is precisely what I am here to do, Chair.
No, you recall that when we adjourned, it was because we could not answer certain questions. You asked that you need to be given time to familiarize yourself with the documents on the issues that were being asked by Honorable Litsie and other issues that relates to council. I think that's the reason why we adjourned the meeting. But then let's move. How long have you been a member of council before being appointed as a Vice-Chancellor?
Yeah, I was a member of council since 20, if I'm not mistaken, I'm just, it should be 2010 or 11 to 2018. Yeah, somewhere there. I'm just off my head,
Are you a member of 2 councils?
Yes, I was.
So you almost served for a period of about 10 years.
It might be Chair, it might not, I would just need to check, but it is quite a number of years. You're correct.
Okay. So a person who has served in council for such a long period of time, would you agree with me that that person carries a lot of institutional memory of that body?
Chair, it's a relative statement that you're putting, and it depends on what capacity that person was occupying. Because I wouldn't want to venture into speculation, Chair, to say, but the virtue that you are here, then you should know more. It depends, in my view.
No, you were a member of council for almost 10 years. You were sitting in council meetings during that period. So I am saying to you that a person who has been in council for almost 10 years carries a lot of institutional memory about that body that you are serving it. I'm putting to you that statement.
Yeah, I cannot agree or disagree with your statement, Chair. It's a statement, you're correct.
Okay. Dr. Ntabeleni, let's not disagree with the obvious. If something is obvious, it's obvious. If something is a fact, it's a fact.
Chair,
In the council for 10 years, you want to tell me that you don't carry institutional memory about that council. What it
Chair,
means to be a member of, what does it then mean to be a member of that body?
Chair, maybe you didn't hear my response. I said to you, I wouldn't definitely say it like you're putting in that, you carry this and that, it depends what you should know based on the role that you occupy. In that space, I can confirm what you say. Because I'll give an example. If I was a chair of council, or if I was a secretary of council, whatever, or not secretary, deputy chairperson of council, the level of what I will know will be much more broader than what an ordinary member of council should know, if you get my point, Chair.
Yes, but what I'm saying is that the decisions of council are taken by council as a body. If there are decisions that are delegated, whoever has taken decisions will come back and report. So for 10 years, you have been sitting in a body that was responsible for ultimately deciding on the future of that university. That's all what I'm saying, is that you would know about what was decided by council, what was not decided by council. That's what I'm saying, Dr.
I think you're correct. I should know because there should be records. The reason why you have records is because you can dispute, people's fading of minds here and there. You got records that each and every, meetings of, of council, there will be a record. There will be minutes that will be ratified, by council. So I think for me, precisely those reasons, you have those records so that you don't say you are a member, you should know. There has to be records, in my view, Chair.
Yeah, but I don't know why we are not agreeing on such a very simple and straightforward issue, Dr. Ntambeleni. Do you understand what it means for a person to have institutional memory? Maybe let's start.
Yes, I do. Yes, I do.
What does it mean?
It means you got relatively some knowledge of the business that you can recall.
Okay, I'm not sure whether that is the full definition of what it means to carry institutional memory, but maybe let's work on whatever that you have said. Documents and records don't tell a full story about the deliberations in a meeting. they will serve to summarize the issues. They won't tell you exactly what happened, how was the matter argued, and all of that. So when you are a member of the body that takes decisions, you will understand and you will have a better perspective of how was that decision arrived at. Now, you have been a member of council for 10 years. You have been attending meetings. You have been participating in the activities of council very actively from the records that we've seen. So you should know and you should have a better perspective of the decisions that were taken by that council. Is it a fair expectation that we should have about you?
Chair, maybe let me put this on record again, just so that we be clear in terms of what we are deliberating. I thought you invited me again so that in my capacity as a Vice-Chancellor to provide you with the missing information that the chair couldn't provide in my capacity as the Vice-Chancellor, which I did. Now, you are now questioning me in my capacity as the member of council. And I want to put it again to you to say, I was not the only member of council. And I want to believe that in your deliberations with this issue, you do procedurally so invited the former chairpersons of council and even the current chairperson of council, because you thought in your view, these are the people who should have a holistic view and account on a number of issues. So I find it very difficult for me, Chair, to sit here and then account on the period of what happened 10 years ago. Because when I was in that council, as I said to you, yes, I will have institutional memory, but on a relative things that were much important to me in this area of science and how the university has to do research, that I can able to talk about, because that was my specialty, why I was seconded in the council. But if now we say on the broader scheme of things, I'll have a challenge, Chair, to really respond to those issues, if I may put it that way.
Okay, I'll come back to your statement, but I want you to answer my question first. Do you think it's a fair expectation that we should have of you, that you should carry institutional memory? You should have a better perspective of the decisions that were taken in your presence by that council?
I cannot admit that, Chair. I don't have a problem with that.
Okay. Let's come back to your statement. You say you've got a problem that you will come here and we want you to account on things happened during your tenure as a member of council. Is that what you are saying to us?
I was just to repeat what I'm saying, that I thought the brief when you invited me here was on my capacity as a Vice-Chancellor to come and hand over documents that you could not receive when the chairperson of council was presented before you. And precisely that's what I'm here for, Chair, to give you those documents and to explain where, if